Welcome to Hall & Estates and Succession Planning, a series of podcasts hosted by Ian Hall and Suzana Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull & Hull in Toronto, here are Ian and Suzana.
Hi, and welcome to Hull & Estate and Succession Planning. You're listening to episode 191 of our podcast on Tuesday, December 15th, 2009.
Hi, Suzana.
Hi there, Ian. How are you today?
I'm well, and yourself?
I'm good, thank you.
Yes? Let's spend some time on that. We haven't spent a lot of time on that.
You always make me laugh when I ask that question, and I can't help myself.
It is part of the feedback we get, that when we do this exchange, it seems a little stiff on how are you?
That's because you just don't care.
Well, you're probably right. At the time of I do today, though. Let's talk about it. I hear you're in the depths of Christmas shopping.
Yes. Absolutely.
So there's a little bit of stress in the room.
We've got a little bit of Christmas concerts going on as well, as I imagine you do as well.
It's the festive season.
That's for sure.
We're busy.
So during our last podcast, we were talking a little bit, as you may recall, Ian, about the duties of a power of attorney or a guardian. And there are many of them. And it's always good to sort of stop, reflect on what it is that you're actually required to do, even though you're caught in the hustle and bustle of doing good and taking care of someone and the emotional part of it. There are, of course, some legal duties that unfortunately come with the job. And so as part and parcel of having duties, there is, of course, a corresponding right to compensation. And I thought what we might do today is to delve a little bit into the concept of, what kind of compensation is an attorney entitled to for all of the good work that they do, whether they do it as a power of attorney for property or a power of attorney for personal care.
I think it's a really good idea because when we mentioned in the last podcast, this idea that you are focused on care and you sometimes let the business side of your job fall is again, we talked about coming back to see your lawyer to get refreshed about your obligations, but the other part of what I found helpful to remind us of our business obligations is to keep in mind, what are we going to get paid for this work? And whether or not we are going to ask for it or not isn't the question you should be asking yourself. You should be setting yourself up to get paid and then decide whether you will take it or not, because that ties into the good for goodness sake. This balancing act, and what we tell our clients is when they come to see us, when they take on this job, is that we, and now and you as well have personally experienced what the effort that's involved with caring for a sick parent, an elderly parent, but anyone who's incapable. The effort is gigantic, adult, child, or parent. So with that is a tremendous, you give up so much of your own time that we have to, let's be frank about compensation. Because the truth is, when someone signs a power of attorney document, a good lawyer will tell them what compensation is.
Right.
And in my experience, nobody says don't pay them. Right? Because they know that they're vulnerable, they need help, they are incapable, and they want good care. And they don't want a daughter, a son, or a trust company to do this for free, because when you do it for free, you tend to pay a little less attention naturally.
That's right.
So it always amazes me when people get surprised by what the compensation is. Not the people who are incapable, because they've already decided to pay the people.
That's right.
But the people who are receiving the money at the other end of the day, whatever's left, are always aghast at how much it cost. But I really do find it's interesting. If we could put the capable person in front of the witness box and bring back magically their evidence, the first question you ask them is, were you expecting to pay these guardians of property or personal care? And they would have almost inevitably said, of course. So that being the reality, the truth is that the courts are very careful to scrutinize what you are going to be paid on the legal side, on the legal fee side. But they are, generally speaking, fairly open to getting people paid for the work they do.
And in Ontario, anyways, under the Substitute Decisions Act, we've got the benefit of a tariff amount that is recognized as the compensation to which a power of attorney is going to be entitled to for doing financial work for an individual. And that, generally speaking, as a rule of thumb, is about 6% of the value of the estate. So it's about 3% of everything that you bring in as a power of attorney when you take control of someone's finances, and then 3% on everything that's paid out at the end of the day. And during the duration of it, you're entitled to about 3/5 of 1% of the average value of the estate that is being looked after. And so from a power of attorney's perspective, typically not nearly enough for all the work that they've done. From the other side's perspective, when you're looking at what's left at the end of the day, always way too much, right?
That's right. Always overpaid. All right, well then we're going to spend some time on this podcast and more when we need it, which we will, on an in-depth look at compensation in the context of power of attorneys. And to do that, of course, we have to start really from ground zero, and that is, what does the statute say? The Substitute Decisions Act is a good illustration. Most capacity legislation is similar to this, so we'll work from the Substitute Decisions Act, but you're going to find similar concepts and similar provisions in across Canada certainly and throughout the United States.
And what we'll refer to during the course of our discussions is Section 40 of our Substitute Decisions Act here in Ontario.
All right, so Section 40 is a starting point for property compensation, and what we've got there is really the what you said before. There's a tariff, there's a prescribed fee, and that section identifies it. And interestingly, in Ontario, there's the amount that the fee is fixed at is done by way of regulation.
Right.
And maybe let's just take a minute there. Why would the statute do it by regulation? What's the difference here, and what does it matter? Why is it unique that way?
I'm presuming, Ian, that the reference to it being in the regulation is simply because it's a lot easier to be able to change it and to raise it, increase it as time needs to be. And I think both of us remember when it wasn't 3%, it was at the 2%, 2.5%, and so it just makes it easier for the economies of scale, essentially.
That's right. So the lawmakers can change it with much more ease when it's in the form of regulation. And I think it's worth at this point just talking a little bit about, because these basic concepts, where they developed from and where they're going to, are important. And what happened was, when Ontario looked at this issue in 1992-94 range, they said that we should put it in by way of a specific reference in the Act as to how much you're going to be paid. Whereas before, as you say, there was this sort of loosey-goosey, what was the way the courts had approached nothing in the statute itself. And quite frankly, in 93, 94, when the regulation was put in, they increased what was the loosey-goosey tariff, and that was 2.5 in, 2.5 out, plus 2/5 of 1% for care and management. So the Act, when it was passed, actually raised the payment for compensation, which was an interesting move, because for many, many years, and continued to be, in an estate, if you're going to administer an estate's assets, it's still about 5%, 2.5 in, 2.5 out in the care and management. But with power of attorney for property, it actually costs more money to be a power of attorney because of the regulation. And I thought it was very helpful that they actually put it in the regulation, so that we have a definitive answer. We don't have to go to court. We have created certainty as to how we're going to get paid. And that comes back to my theory that people who sign their powers of attorney, almost always know that they're going to get paid, and now they know how much they're going to get paid. And so the expectation's there. So at the other end of the day, when we're litigating over this, beneficiaries have to be very sensitive to the fact that a court is going to know that too.
That's right.
So a fight over that can be a bit of a dangerous game. All right, so we've started with our Section 40 analysis. We've talked about some of the policy reasons behind getting paid for compensation, and we'll continue our in-depth discussion on compensation for powers of attorney in our next podcast. So thanks very much, Suzana.
Thanks to you too, Ian.
You have been listening to Hall on Estates and Succession Planning by Ian Hall and Suzana Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.